The will. When dealing with wills, it's helpful to know a few simple legal terms. The person who makes a will is called a testator. Administering a will and distributing an estate is called probate. A will usually names personal representatives, the executors. These are the people responsible for applying for probate, collecting assets, and distributing the estate. Instead of rewriting a will, the testator may make amendments by signing another document called a codicil. A codicil is just as important as a will, and all the same rules apply, but to keep things simple, we'll just refer to the will from now on. Finding the original will. When someone dies, it's important to find their original will as soon as possible. That's because the process of probate requires the original document and not a copy. There are a number of places to check when looking for an original will. These include the deceased's home, safekeeping wallets or boxes at a bank or building society, the principal probate registry, as they offer a will deposit service, and the solicitor or will writer who drafted the will, as many offer a storage service. If none of these prove successful and you're certain there was a will, then there are some other searches you can carry out. Visit our Knowledge Centre to find out more. Checking a will is valid. For a will to be valid, it must be in writing, signed by the deceased in the presence of two witnesses, countersigned by the two witnesses. If you're happy the will seems to be valid, you need to check it hasn't been revoked or cancelled. This can happen in a number of ways. A will can be revoked by a later will, which states that all previous wills have been revoked. This is one reason why it's important to make sure that you found the latest valid will of the testator. A will can also be revoked by marriage. If someone makes a will and gets married later, the will is automatically revoked unless it specifically states that it's being made in anticipation of the particular marriage. Finally, a will can be revoked by destruction. If an original will can't be found and the testator definitely had it in their possession, then they may have decided to destroy it. Destroying a will automatically revokes it. This is another reason why it's so important to find the original document. Important points. A will's physical condition is very important. If there are signs of tampering, the probate registry may question if it's complete. In other words, whether there were other documents attached detailing the testator's wishes, or if the testator tried to destroy it during their life. There are a few simple rules to follow when dealing with original wills. Never staple or paperclip anything to a will. Never remove documents already stapled or clipped to a will, or take a stapled will apart, for example, to photocopy it. Never write on a will. Always keep it in a safe place. Always make a copy, if you can, carefully and without taking it apart. Always use special or recorded delivery if you're posting a will to a solicitor or the probate registry when applying for probate. There are also a number of situations that are likely to cause problems but don't necessarily invalidate the will. These include if the will has no date, if a beneficiary is also a witness, if parts have been crossed out, or if it simply doesn't make sense. In all these situations, it's a good idea to seek further legal advice. Visit our Knowledge Centre for more information about whether a will is valid. Top tip: finding the original will document can be tricky. It's worth checking the deceased's bank statement to see if they made regular payments to a solicitor or will writing company who could be storing the will.